of background on him. He is currently the co-deputy chairperson of the Bar Council Constitutional Law Committee and also the chairperson of the Bar Council National Young Lawyers Committee. Syahredzan Johan is currently a partner at Master Rise and Partners.
Hello everyone, just give me a moment while I adjust the mic. This always happens. The virtues of being rather short. I think so. Can you hear me?
Yes.
It's my okay. Okay, hello everyone. Welcome back to the forum. Now, unfortunately, I have the difficult task of presenting something after lunch. Now, this usually means two things. One, people will take their time to come in, as I can see now from up here. It's like patches of emptiness. And number two, hopefully they'll come slowly. And number two, if your presentation is boring, and I hope mine isn't, there is that possibility that the audience might just close off. So I hope that doesn't happen, but soldier on we must. We have been given this slot by Tindak Malaysia and the Bar Council, and on behalf of Projek Beres, we'd like to thank the both of them for organizing this forum and also for allowing us, Projek Beres, to have this slot today. Now, my presentation today for you is basically an introduction of who we, Projek Beres, are and also what we propose to do. I just want to say that the computer is really cool because it actually shows the next slide as well. So I will know the next slide. So kudos to whoever set this up. Okay. Some opening remarks. Who we are? Well, we are a citizen-initiated collaboration between Malaysians, local and abroad, having access to a variety of election-related resources and with the aim to provide a total and holistic proposal to improve our electoral democracy that takes into account contemporary factors and interests. Now, the objective is to improve the credibility and integrity of the Malaysian electoral system in line with established principles and practices in other parts of the world. And lastly, what we have undertaken so far is basically a review of the Federal Constitution. Now, just to elaborate on these slides, Projek Beres is not an NGO, so ROS, please don't look for us. We are more of a collective of concerned citizens. And most of us are actually abroad, meaning a lot of us are actually outside of Malaysia, working or studying or whatever. And most of us as well are not lawyers. And as you'll see later, this is actually quite amazing because Projek Beres has actually made some significant proposals to amend the Federal Constitution. And once you put this in context of the fact that a lot of the people who come up with these proposals are not lawyers, it becomes quite amazing actually. And the people behind Projek Beres have been working on this for the past year or so and came up with this proposal. Now, at this point in time, I must put on record that I'm just a spokesperson for the group. I did not put a lot of input, I did not do a lot of the behind-the-scenes work. They are all being done by these concerned citizens, these citizens who want a better Malaysia, so to speak. And my input, my personal input to it is very minimal. And so, the reason why I would say that is because I don't want people to think that this is initiated by lawyers or whoever. It's actually by concerned citizens who undertook a review of the Federal Constitution. And to know more about us, you can actually access our FAQ, frequently asked questions, which are available outside at our booth. Okay, let's move on. So what's currently set up in our Federal Constitution? Now, what you have is basically concepts with regards to general concepts, fundamental liberties, institutions, and of course you have the part on elections and election-related institutions, for example, the Elections Commission. Now, what Projek Beres is proposing are substantial amendments to the Federal Constitution. Now, this may sound slightly radical, some might even call it seditious, but don't forget, we have made 42 amending legislations to the Federal Constitution since independence. And I think, as Professor Shad Faruqi has pointed out, I think a few years ago, individual amendments to the Federal Constitution, about 650. That's a lot. Okay? And you compare that to perhaps the American Constitution, and you see that we have a habit of amending the Federal Constitution. Now, some of these amendments are major, of course. For example, we've got amending the Federal Constitution from the Persekutuan Tanah Melayu to the Federation of Malaysia. Also, amendments such as taking the judicial power of the Federation away from the courts. And of course, you also have some minor and some would say unnecessary amendments, such as the last amendment which was made, just so that the previous EC chairman could stay on for another year before he had to retire. So what they did was, they extended the retirement age of the previous EC chairman. So we have had constitutional amendments before this. And I think we must also remember that a constitution cannot be static. It cannot be set in stone. Okay, this is not the Ten Commandments or some holy book or anything like that. These are not set in stone. The constitution should be able to reflect changing aspirations, and we should be able to amend the constitution if we feel that what we have right now might not reflect our current aspirations. And I think sitting here in this forum, I'm sure you've heard countless number of times how the speakers have said, the law is such, the Federal Constitution is such, we're constrained by the law and all that. And what best to change all that than to make amendments to the Federal Constitution? We feel that for us to make a comprehensive and complete reform of the electoral system, you cannot do so without touching the Federal Constitution. So, what's the focus that we have on when we review the Federal Constitution? Well, actually there's 5 parts to it. The first is the equality of voter representation. We want to have a more proportionate voter representation. Number 2, we want to set conditions for constituency delimitation. Number 3, we want to reform the Election Commission. Number 4, how government functions are discharged during the dissolution of Parliament and formation of a new Parliament, meaning we want to propose a codified caretaker government type of concept of system into a Federal Constitution. And lastly, we are proposing an oversight mechanism, an ombudsman when it comes to election laws. This is just what we have undertaken for now, because the whole idea of Projek Beres is to have to make proposals and of amendments or perhaps even new type of legislations in order to achieve a more wholesome electoral reform. So our first step is to actually make these proposals with regards to the Federal Constitution. Okay. moving on to the first part, which is equality of voter representation. And in order to do this, we basically make three proposals. One, to the composition of the Dewan Rakyat. Number two, to the composition of the Senate, or the Dewan Negara. And number three, to bring back local government elections. Okay. Let's look at the first one, which is the Dewan Rakyat, or the House of Representatives. As we know, currently we have 222 MPs, members of Parliament, in the Dewan Rakyat from all over Malaysia. We are proposing that this be increased to 230 members. And this increase basically follows two methodologies. The first is with regards to the Dewan Rakyat seats. It must reflect voter population when we talk about West Malaysia. So, for example, in Selangor, there should be an increase because there's basically more voters in Selangor. And in states like Johor, there should be a decrease. And this redistribution of seats is to follow a uniform electoral quota system applicable to the unit area of West Malaysia, which I think later on we'll explore, because we're not going to touch on that in great depth, because we've got a lot of proposals here. But we are going to take on what some speakers have actually talked about, I think previously or later. With regards to Sabah and Sarawak seats, we are proposing an increase as well, because we want to reflect the ratio of seats that has been agreed upon in the Malaysia Agreement of 1963. So with this redistribution, all voters, as much as possible, are treated as equally as possible. So we don't want a situation where the value of your vote is lessened because at the end of the day you are one voter in 100,000, whereas in another constituency you are one voter in 7,000, for example. I think you know all the problems with this. Now, okay. An illustration of this, if you can see, if the proposals that we're making, if it was implemented before the 13th general election, the distribution of seats would look like the Gambar Raja, the pie chart on your right, I think. Yeah. So it would still mean that the Barisan Nasional would win, but the proportion, the percentage of seats that they win would be lesser. With regards to the Dewan Negara, we are still maintaining, we propose that it still be maintained to 70 seats, but an adjustment is made so that the appointments made by the Yang Tuan Agong is increased from 40 to 42, and the federal territories of KL, Labuan and Putrajaya are all allocated collectively 2 seats instead of 4 before this. The other amendment that we are proposing is, of course, local council elections. In the federal constitution amendments itself, we have not put forth any amendments, substantial amendments with regards to this, because it's already provided for. It's for Parliament on the stage to actually make laws with regards to local council elections. And I think the benefits of local council elections, I don't need to remind you of it. I think you're quite clear as well. So just to recap, with regards to the first part of equality of voter representation, we are proposing changes to the composition of the House of Representatives, composition of the Senate, and to bring back local government election. Next, our second area of review is with regards to delimitation. Right. So these are criteria which we propose that should be inserted into the 13th schedule to change the current criteria in order to have more equal voter representation. First of all is the criteria of representativeness. It must reflect the communities of interest and common features as much as possible. So you don't want, for example, one kampung and suddenly you've got a territorial boundary or parliamentary boundary cutting across the kampung, for example. Number two, equality of voting strength. West Malaysia, the variance should not exceed plus minus 10% from the electoral quota of West Malaysia. East Malaysia, similarly, variance not to exceed plus or minus 10% from the electoral quota of East Malaysia. And the ratio of state assembly seats to federal seats should be not less than 2. Number three, the criteria on transparency. We should have more public hearings in order to, when you want to undergo a delimitation exercise. Number four, non-discrimination. This means that we need to safeguard minorities. Fragmentation of geographically concentrated minority groups are not permitted. Just to give an example, if you have an Orang Asli community in a particular area, there should not be a line across the Orang Asli community, so you divide the community artificially, so to speak, in terms of the borders, whereas actually you are one group of people there in one village of one Orang Asli village, for example. And number five, must follow as close as possible to the electoral quota that is going to be set out. We are also proposing a new institution to oversee delimitation, which I will touch on slightly later in my presentation. The next focus is on revamping the Electoral Commission. Number one, we want to ensure independence. So members are to be appointed by the Yang Tuan Agong as currently practice, and we say also it must be with the concurrence of the opposition leader. And I am aware that opposition leader in the Federal Constitution is that it is not recognized per se. So one of the amendments would be to actually recognize the office of the opposition leader. And also in making this appointment, there would be a public hearing before a judge of the federal court, and after that, once the hearing is done to assess the suitability of the members to be proposed into the EC, this will then be presented to the Yang Tuan Agong. And the Yang Tuan Agong is also not bound by Article 40, which says that he must act on the advice of the Prime Minister. And with regard to EC members, they can be removed if it turns out that they hold office. We have put here membership in political party. Actually, the actual amendments that we propose are actually holding positions, official positions, like secretary or vice president or whatever, of the political party. So you can still be an ordinary member, but you cannot hold positions. Also, EC members, once they stop being EC members, are not eligible to be elected as MPs, senators, ADUN, and local council members during the 2 years period after they stop being EC members. The other reform that we are proposing in regards to EC is that, as I mentioned, we are taking away the delimitation function of the EC and putting it to a new boundaries provision, which I will talk about later. And I think this is to ensure that the EC, the boundaries commission, is separate from the EC, and the functions of delimitation would be taken away from the EC in order to ensure independence. So the EC's job, the EC's role, therefore, is just with regards to elections and not, drawing up boundaries or anything like that. And we also want or propose that the EC take up this new role of having oversight on the registration of political parties. Therefore, as it stands right now, this is being done by the Registrar of Societies. So political parties will have to be registered with the Registrar of Societies. We want to take that away from the Registrar of Societies, and we want to put it under the purview of the Elections Commission, so that they have the oversight on the registration of political parties and organization. And all these proposals are in order to have an EC which is truly independent, not just on paper, so to speak, but de facto independent. And I think the system as it stands right now might not lead to that, because you've got the EC being proposed by, or rather, the young people are appointing the EC members following the advice of the Prime Minister, for example. So all these things, in order to ensure true independence, we are making these proposals. And to illustrate that, we show you photos of reference. Next is on delimitation. I think the problem with gerrymandering and all that, we're all clear about that. I think we've heard throughout yesterday and today as well, problems with gerrymandering and delimitation and all that. And in fact, if you're here and you still don't know why it's gerrymandering and the problems with current delimitation, then you can watch Tindak, Malaysia's video on this. So delimitation, we say that it should be undertaken by Boundaries Commission. This is similar to the Boundaries Commission of the UK and New Zealand, and it's no longer done by the EC. Boundaries Commission may increase or decrease number of constituencies according to the delimitation criteria, which is currently set out in the 13th schedule, and which we make proposals to amend as well. And the Parliament cannot actually amend and reject the determination of the Boundaries Commission. So what about appointment process of members of the Boundaries Commission? Well, the Boundaries Commission, in order to ensure independence, again are to be appointed by the Yang Tuan Agong in consultation with the Conference of Ruler and with the Conference of the Opposition Leader. And again, His Majesty, His Royal Highness is not bound by Article 40, which says that he must act upon advice of the Prime Minister. And again, criteria for the appointment of a member of Boundaries Commission must have a public hearing before a judge in federal court, and then in order to determine the suitability of the person proposed to be a member of the Boundaries Commission, and thereafter the result of the hearing will then be presented to His Royal Highness, the Yang Tuan Agong. Criteria for removal, again, as the Elections Commission, this is actually inaccurate, it's actually membership in a political party and holding a post, official position in the political party. And again, not eligible to be elected as MP, Senator, Advocate, local council member during the 2 period after he ceased to become a member of the EC. Okay, moving on. The other new institution that we propose is an election ombudsman office. Okay, and it's basically to have oversight into the Elections Commission, to inquire into, review and address complaints and grievances with respect to the conduct of the EC and the Boundaries Commission. Again, independence, in order to ensure independence, appointment of the ombudsman members, there are 3 members, public hearings, again to assess stability, consultation with the conference ruler, and the concurrence of the opposition leader. And again, His Royal Highness is not bound by Article 40. What the Elections Commission can do is, once they have conducted a review and inquire into the complaints and grievances with respect to the conduct of the EC and the Boundaries Commission, they can actually issue orders for corrective action to be taken. And the Elections Commission may also recommend removal of a member of the caretaker government. Now, we will touch on this, I think, after this slide, after this, with regards to caretaker government. So, for example, if you're not happy with how the EC or the Boundaries Commission is coming up with regulations, or how the EC is coming up with regulations with regards to the conduct of the elections, you can bring this to this proposed Elections Ombudsman Office. And if the Election Ombudsman Office feels that there needs to be corrective action, they can issue out orders. Okay, all this is in order to take away the concentration of powers on the EC, because actually, despite what the EC says, the EC actually has a lot of powers. It is not just a government department, it is actually a constitutional institution. So they cannot then now say that actually their hands are tied and all these things, because they have that power. And we want to take away so that it's not concentrated on them, in order to ensure that there are checks and balances between the various institutions. The other new proposal that we are making is to have an independent caretaker government. Now, this is a bit different from the caretaker government which we know in the UK or in Australia or New Zealand, where basically the current government just takes off its hat as a government which has been elected. Once Parliament is dissolved, they actually just take off the hat and assume the mantle, the role of a caretaker government. What we are proposing is a system that is practiced in Pakistan, and a neutral, independent caretaker government, which will take office once Parliament is dissolved and until a new government can be formed. So this is different. So we're not, the current government, which is in power, cannot then continue being the government, because there's always that possibility that they might abuse the position they are in, the fact that they are in power to I don't know, use government resources in order to campaign, for example. So in order to avoid that, we say that once Parliament is dissolved, the executive is also then dissolved, or they would have to resign, and a new caretaker government, which comprises of members who are not involved in the election. So he's not in contention, they are not in contention in the election. So it's a totally independent or neutral government. And this will be appointed by the Yang Tuan Agong, and it has to be agreed upon by the Prime Minister, the previous Prime Minister, and previous opposition leader, so that to ensure that the person that we put as the interim government, interim Prime Minister or whatever, is someone that has at least the confidence or independence with regards to both sides of the political divide. And also, to also introduce a code of conduct for the caretaker government, meaning what can the caretaker government do and what it cannot do in this interim period, bearing in mind that it is effectively an unelected government, and it is just there in order to ensure that the business of the executive continue to be run whilst we have the general elections. Okay, next. And this is again, as I mentioned, this is a system that's being practiced in Pakistan. They had it in Bangladesh, but I think they abolished it some time back. But in Pakistan, this is still the system. Lastly, our last proposal is with regards to referendum. And this is actually quite new, and some say quite radical or revolutionary in that sense, because we are actually proposing that a system of referendum be put into the federal constitution, so it becomes a constitutional mechanism. And we are proposing 3 types of referendums. The first is what we call a mandatory referendum. I think we're all quite clear on what is referendum, right? I think we're all looking at the UK right now, because Scotland is going to be voting on whether to secede from the United Kingdom, I think sometime this year. So that is happening in the UK. And I think recently, I think about 3 or 4 years ago, they had a referendum on whether more proportional, the FPTP system should stay or not. That's in the UK. So we are proposing, number one, a mandatory referendum. Just to explain mandatory referendum, number one, you must have a referendum whenever specific or substantial amendments to the federal constitutions are proposed. So you cannot amend the constitution without going through a referendum. Number two, whenever we want to admit new territories, which seem unlikely, or when a territory wants to secede, this is slightly more likely than new territories coming to us. And number three, when a legislation under Article 149, the powers in order to deal with subversive so-called elements in society, which has given birth to such wonderful laws like the ISA and also SOSMA. If this type of legislation is to continue for more than 1 year, then we say you must have a referendum in order to find out whether the people think that this needs to continue for more than a year. So these 3 types of situations where we say that a referendum must be held. Number 2, a referendum by citizens. Any citizen of the Federation who has attained the age of 21 years may launch or sign a popular initiative and request for a referendum in federal and state matters. Such request for a memorandum must within 365 days or longer, if rejected, a petition is resubmitted, be perfected by a petition signed by 10% of registered voters before a referendum may take place. So meaning, you cannot just one day decide I'm going to have a referendum to determine whether Justin Bieber songs are actually considered music, and then just submit it and hope that it will become a referendum, because you need 10% of the voters to actually sign and support this referendum for it to actually take place. So this, and 10% is actually a lot. 10% of the voters is actually a lot. So this would ensure that only so-called public interest issue, as reflected by the 10%, are to the referendum. And number 3 is referendum initiated by the federal or state governments. We propose that federal or state governments may initiate a referendum on federal or state matters, as the case may be. And for such referendum, only registered, for state matters, only registered voters resident in the state concerned shall be eligible to vote, which actually makes sense. So perhaps you can have a referendum as to whether you want Selangorians want to change your country besar. Since it's apparently being forced on us. In a nutshell, 20 federal constitution proposals with regards to the electoral reform. If you can understand this chart, because I'm having trouble understanding it myself, but it basically summarizes our proposals. And if you're interested to know more about what we're proposing, because I only have about 45 minutes and my time is nearly up. And there's a lot of proposals and I'm just doing my best to summarize it. What we have done is we have actually put up our proposals, the executive summary of our proposals on our Facebook page. You can also find out more about us from our Facebook page, about Projek Beres from our Facebook page, which is, unfortunately, it's not here. I'm not sure whether I can type it out here. Or is there a function? Pen. Okay. Let's try this. Okay. It's improvisation. Right. You try using a pointer to do this. I wanted to become a doctor, that's why my handwriting is like this. Then I found out I'm scared of that. So, seeing that there's nothing else to do, I became a lawyer. That and the fact that I cannot count. So that should read www.facebook.com. Oh, yeah, it's this one, Projek Beres. Okay? So, www.facebook.com/Projek Beres. Go to our Facebook page. There will be a website soon, but right now we have a Facebook page, and our proposals are there. The executive summary of our proposals are there. The actual federal constitution amendments are not there yet. We have just an executive summary because we need slightly need to fine-tune the language and all that. But the proposals are there. The executive summary is there, and also frequently asked questions on Projek Beres. So moving forward. This is actually not the end game, this is actually the start. We're just introducing ourselves. What we want to do to move forward is we want to bring these proposals to the stakeholders, to political stakeholders from both sides of the divide. We want to say that, look, I think we can somewhat agree that we need to reform our electoral system. I think generally we can come to a consensus that what we have right now might not reflect our aspirations as a maturing society. We want something better. And in order for that something better to happen, we think that it must involve a review of the federal constitution and amendments of the federal constitution. So we are willing to engage with anyone who's willing to work with us from both sides of the political divide, even the Elections Commission, if they are willing also to come. And please bear in mind that these are just our proposals. We're not saying that this is the only workable model. And we are actually willing to discuss and even make changes if need be. But we want to say that, look, we all can see that there is a problem. But we want to say that we are offering one solution in the form of these proposals. We need to start looking at the solutions to the problems we have with our electoral system, because I think enough people know that there is a problem. Now it's time to work together towards solving those problems. And if we can't solve those problems with the current legislation, then perhaps we need to move out from there. And perhaps we need some sort of bipartisan effort, tripartisan, political parties from both sides of the political divide, NGOs and collectives such as us, again, RS, please don't look for us, to come together and sit down and start discussing about these things. So hopefully this is just the start of our so-called initiative. Please criticize it, have a look at these proposals. If you think that referendums can never work in Malaysia, go ahead and criticize, talk about it. Let's talk about it. We're not talking enough. And then we're not doing, after talking, we're not doing enough as well. So let's do something, and if you're interested, you can either contact us, or I'm on Twitter, you can just tweet me. Okay? Shall I write down my Twitter? No need. So that's it. Thank you so much. Right on time. This is I think the only time that I've managed to finish a presentation on time. Thank you so much again to Tindak Malaysia, to the Bar Council for allowing us this opportunity to be here. And thank you all for not falling asleep and for coming and actually looking like you understand what I'm saying. That's all. Thank you.